Yes, start.
Uh, Hello everyone. Today we are here to present our presentation on concept of contract and tort law. So our first case is Dave and Karen. While Dave and Karen had a valid contract which was completely based upon mutual trust and understanding because of blood relation, there is no question that all the necessary requirements offer acceptance. Karen accepted the offer made by Dave and moved to Sydney. And consideration, the contract was considered or agreed upon by both the parties, were fulfilled, making it a valid contract. There was no agreement between the parties upon essential terms of pitiful proposals. Wakeling versus Rapley, 1951. The presumption that agreements between family members do not intend to create legal relations were rebunked. The plaintiff won the case. Second case, couple versus bank. In this case, as stated, the Lebanese couple have no other choice but to pay the amount addresses in the contract between them and the bank. The bank did not have an idea that the couple is not proficient in English and do not understand all of the terms of the contract. However, their son had to be guarantee for the loan taken by his parents to pay off his debts. Based on the court, the bank conduct was dishonest, unfair, and unjust. Because of their distinct disadvantages, the parties' capability to self defense became technical barriers. The bank's actions were immoral because it must have known or should have known about the parents' incapacity. The judge concluded that the contract was voidable under these circumstances. Now, my friend Hitesh Shibbar will continue the presentation.
Coming forward with the contract law, we have got two more cases, and the first one is Brad and Jenny versus Angie. As we can see, Brad and Jenny are liable to sue Angie, whom had not provided the wood-fired oven on time, leading to loss in their business for straight 4 days, and also an extra expense of salaries of the daily waged workers in the restaurant. This case is very much similar to the Victoria Laundry Limited versus Newman Industries Limited in 1949. The supplier was conscious that perhaps the plaintiff required a boiler urgently for their business in order to take advantage of good trading conditions and to expand their operations. The same way that happened in Brad and Jenny's case, as they required a wood fired oven on an urgent basis, as they need to expand their business and were not able to do so because they did not receive any wood fired oven from the Angie on time. The defendants must have believed that there will be a loss if there was a delay. Thus, the court determined that the laundry profits were recoverable. The plaintiffs had negotiated a lucrative government dyeing contract. However, the defendants are uninformed of this. Therefore, it is essential that Brad and Jennifer had made it apparent that they could not operate their business for the lawsuit of being successful. Next case is Jean versus Supermarket. Sean fell on the grapes in pet section. The manager of the supermarket breached its duty of care, which created physical barrier for its customers like Sean. Furthermore, after the accident, the manager of the supermarket is not showing any pity or provides any compensation or damages to Sean, which may increase the breach of care. In this context, the wrongs activity of 1958 supported Sean to conduct a case for the breach of duty of care. Furthermore, focusing on the Civil Liability Act of 1936, Sean can accumulate compensation for damage to the enjoyment of life, pain, and suffering, and physical and psychological injury. Hence, Sean can conduct a case against the supermarket and its duty breaching, which can help Sean to accumulate compensation for physical and psychological damages. Coming forward, I would like to I would like to come forward with my partner Khemraj Joshi, who will take this thing further. Over to you, Khem.
Thank you, Hitesh. Thank you for your presentation. Hello, everyone. It's me, Khemraj Joshi. I'm going to present on two more cases. It's Lan versus Johnny and Sam versus Polly. And I'm going to start with Lan versus Johnny. In this case, one day Lan parked his own car in front of the garage, which was usually closed during this session. Land cleaned the pool. A hailstorm damages the car of Land, which creates a property loss for Land. After the incident, Lan asked Johnny to provide the damage compensation for the car, as the car was placed in front of the garage. In this context, if Lan tries to file a case against Johnny and tries to grab compensation from his landlord, Lan needs to focus on the Personal Property Securities Act 2019 legislation. This act supports land to grab legal support in the case, and also supports the applicants to grab compensation or damage controller cost from the above authorities. And Land fulfills his own duty even in a hailstorm, and due to this reason, Land was not able to park his car in a safe place. In this context, if Johnny opens his own garage for Land to park his car, it cannot even affect. And the last case is about Sam versus Polly. In this case, Sam and Polly were two friends. One night, Polly accepts a lift from Sam, and Sam was to grab his driving license just 2 weeks before. Suddenly, the rain started, and Polly asked Sam to reduce the speed of the car and slow down in the road. Sam drives his car within the speed limit and does not cross the speed limit. However, after some time, Sam is not able to retain the balance and the car hits the telegraph pole on the road. In this context, Personal Injuries Proceedings Act 2022 supports individuals in Australia to grab legal support from for medical expenses, loss of income, and others due to negligence. And the other outcome is like there are four elements of tort negligence duty: breakup duty, damages, as well as causation. Based on the case study, Sam was not forced by Polly to ride the car and take the lift from him, and this created a strong point of defense for Sam. It is the last case, and we have done the presentation on contract law and tort law. Thank you, everyone. Thank you, our group, mm, Hitesh, Akash, and myself. And hope you do well in another presentation. Thank you, everyone.